Hi everybody, welcome to my channel, Life, Law, Bin. Hi everyone, welcome back to the channel. I am very excited today because we do have some interesting content for you as usual. I have with me Mr. Matthew Eastman. He's a fellow advocate as I am at LPC Law, and we did meet at a work social. So I was always enthused to bring Matthew onto the channel because today we're actually talking about an alternative or another option besides the bar or besides the roles familiarly known as the solicitor route. We're talking about the Chartered Institute of Legal Executives. You probably would have known this as CILEX. And before we even delve into that, I do want to mention a fun fact about Matthew. He is into gardening, and his successes have been potatoes and lettuce. So guess what? If we're craving French fries or some baked potatoes, we know who to we know who to contact. Matthew, thank you so much for joining us. Welcome.
Thank you for having me.
Good. Let's get started because I think this is really, really exciting and we're really interested in hearing your journey here. So let's start from the beginning, Matthew. Let's start with your educational experience. So we'd like for you to provide a brief overview of your experience studying at the University of Sussex.
I'm grateful, yes, and I'm happy to break down that question into three, if I may. In terms of the practical side of the law degree that I tried to take on board alongside the theoretical underpinnings. Additionally, I will try to point out some adverse risks to my approach because I'm not infallible, and also there have been things that I've learned from in the past. And then also the relevance of my approach to academia to my practice today. So on that basis, starting with the time at Sussex, I was able to get a solid grounding in the theory of English and Welsh and EU law. Now, I tried not to limit that to just solely the university experience out of a textbook. But what I wanted to do was get more actively involved in the practical side. And I tried to do this a lot from engaging early on with lots of mooting and mock trials any chance I got. And at Sussex, I found that I was more amenable to doing moots. There was maybe one or two mock trials, one through the university, another one I had to go to London to do. But that was really a very limited exposure to mock trials, but lots of mooting. The other thing that I found quite not interesting, but engaging in terms of being able to take the theoretical underpinnings of the law degree and apply it to the practical foundations and seeing the justice system at work, as you will, is actually going to Crown Courts. I used Crown Courts because I found them the easiest to get into. For the longest time, for some reason, whenever I tried to get into a civil case, they always used to say, "Oh, are you a party?" And I would say no. And then they say, "Oh, you can't come in." I think that might be slightly against the open justice principle, but in any event, I'm not going to cause a fuss about it. It was just easier to get into the Crown Courts, and that's where I ended up, which I don't regret at all, because actually that's day in and day out oral advocacy on your feet. And what you're seeing there is expert advocates in their finest. And in that respect, there is an adverse risk of doing that. And the adverse risk is when it came to essay writing on the law degree, I always wanted to do my essays judgment style. And they're not looking for a judgment, they're looking for an academic essay. So there is, whilst I do find relating the theoretical underpinnings to the practical unfoldings of the justice system at large is vital experience, it does have a risk in the sense that if you're like me, you might try to make your essays a judgment, and that's not what the academic tutors are looking for. So effectively what I'm doing is I am trying to play as much as I can a full-haired individual, getting off the Brighton and Hove City Omnibus for the first time, sitting at the back of the courtroom and engaging with that to try to then relate that to how the university academic approach to law from a textbook relates. And with that, I hope to see it from both sides. Now, how does that relate to my practice today when actually I took that out of the criminal courts, and today I'm exclusively civil? Well, again, it comes down to the oral advocacy side. The substance of the law changes, yes, absolutely, but the audience changes as well. But of course, the boiling it down to what you're doing, you're trying to persuade an audience, and that's what they did, and that's what I learned from them what to do, albeit to a different audience, and in fact, perhaps an audience with more hats, but nonetheless, I'm still trying to persuade an audience, and that's the transferable skill that I can take from the Crown Courts and apply to the civil arena.
I'm so happy that you kind of structured this as more of a comparative analysis, because many times law students kind of isolate the two. And I think it makes it so much more difficult or more challenging to enter the world of work and to really wrap your head around the practicalities. So I'm happy that you kind of analyzed it as a whole, because we need to stop seeing the academic side as operating in isolation to the practicalities of it, and really think of a blended or marrying the two concepts. Because I think many of us struggle for a little bit when we enter the world of work. And I think that is obvious when we become advocates, because we usually become advocates after we've finished our academic training, and then you recognize, whoa, I've been taught a lot, but really and truly in the world of work there is a lot I still do not know. So I'm happy that you were able to kind of analyze that, and I think it brings us neatly onto what would be the more practical aspect of academia, which would be the bar course. That's when you're supposed to be on your feet. How did you find that experience, and how has that experience helped you today?
Yes, on the bar course, it is designed to get the more procedural side of everything. Again, though, it too is out of a textbook. Now, they do try to engage with you and try to get you up on your feet doing advocacy in a controlled but fictional environment. And that way, not being let loose on the clients, if things go wrong, then you get feedback and constructive feedback. And then hopefully you adjust that before your assessments, because that will then achieve a final grade. Of course, with that, there are the difficulty is I did the bar course in the 1-year program, and it is quite an intense program to do in 1 year with all the different modules that you have to cover. So the downside that I found was that I did not have as much time during that bar course to do the practical side that I had tried to devote to my theoretical studies, such as getting out for mooting and mock trials. In fact, I think I had to do a few dinings with my inn. I think I might have done one moot or watched a moot, but it was a lot less than what I was able to do with Sussex. I might have been all mooted out by that point, because I did do a lot of mooting with Sussex. But even if I hadn't been mooted out, there were the opportunities there, although bearing in mind it's over a year, not 3 years. But within that 1 year period, there would have been more opportunities for my time to be able to manage it with the law degree than I found that I'd be able to manage it with the bar course. And indeed, that was pretty much the same for mini-pupillages, save for the fact that I was able to undertake one mini-pupillage, which was quite helpful on the bar course. But again, I think I did a few more. Well, there was 2 I did during my time at Sussex, and 1 that came after the bar course. Again, all things considered, that bar course was eat, sleep, and breathe the bar course. It also was helped from the fact that I had to commute. Well, I didn't have to, but I chose to commute, and I would commute into London from Brighton and Hove, and that then took out some time as well. Although it was only 3 days a week, it was nonetheless a full-time commute almost, and also a full-time study there really was limited, if any, time available for getting that practical exposure, save for when it came to the third term. Because in the third term, I was then able to take an optional module, and I did a domestic violence training, and that was quite insightful and quite practical. And I was actually able to take with that volunteer experience, which helped to bridge that gap with the National Center for Domestic Violence. So save for that, it was pretty much glued to textbooks and then on your feet with fictional advocacy, but not much exposure aside from one mini-pupillage and the NCDV course to actually the practical side of it. I don't think I had much time at all for trying to be that full-bodied head individual sitting at the back of the courtroom and observing justice unfold before my eyes on that course.
I know that you're absolutely correct because I completed my bar course actually earlier this year.
Oh,
And
congratulations.
yes, thank you. And it was definitely over a period of a year that I did that. And it was intense. It was
Yes.
absolutely intense. And even to schedule yourself in for your qualifying sessions and any other work experience, because I did my master's with that bar course, it was overwhelming. And I definitely don't think I would have been able to get any practical experience unless I did my master's with that. Now, my master's was a pro bono kind of master's, which meant that I did work experience. I worked in a legal advice clinic and assisted at some tribunal hearings by making submissions, etc. But aside from that, if I didn't do the LLM, which I know was ushered in more recent times, I really wouldn't have had any additional experience really to add to my CV besides the fictional advocacy. And of course, there's a place for it, but it really isn't a substitute for the reality of the courts when we do enter. Now, Matthew, before I even go on, I must ask, because you're Canadian, about your experience studying as an international student. I've had challenges myself. So even before we go into that, why did you decide to study law in the UK as opposed to Canada?
There's a variety of reasons, and perhaps that was the one when I was thinking of uh, this process in advance. The one that I probably spent the most time on trying to decide why the UK. And I think the way that I can boil it down is the birthplace of the common law system. And I was looking for a new adventure as well. I'd been in Canada before, and I wanted something new and different. And then I thought that, well, if I'm going to get a law degree, let's go off and get it from the birthplace of the common law system, and then come back and apply it to some variant. Because at that time, I was still considering the possibility of coming back and qualifying. There is, of course, the other vantage point that it is kind of an LSAT dodge. And with that, Canada's set up in terms of a entrance exam. And what they do is a form of standardized testing. And it actually has a benefit. And that benefit is trying to screen out, prior to spending vast sums of money chasing a piece of paper qualification that you'll never actually be able to utilize in practice. They try to screen out their students before they go into the legal qualification process from academia onwards. Now, in England, the way they tend to work it is the bar course did introduce a BCAT, which is working along the same principle, but doesn't quite have the same effect in terms of numbers. But where they are with their traditional process was to take everybody in and then filter them out along the way. But unfortunately, that gets costly and that gets expensive. So Canada tries to limit that by treating law as a postgraduate degree and only a postgraduate degree, and only if you pass not a BCAT, but an LSAT, similar to medicine, where you have to pass an MCAT, can you then get in and go? There's some exceptions to that rule. But the problem is with that approach is that some people just don't test well. So then you're excluding diamonds in the rough. So you've got to remember with law, yes, it creates a good general rule, but there's always an exception to those rules. And with that, the stone that the builder refused becomes the keystone. So you never want to just put all your eggs on the basis of that standardized test, although as a general rule, it does achieve a good point. Now that is not the reason why I came over to the UK. I did want a law degree from the United Kingdom because it is the birthplace of the common law system, England and Wales in particular, because Scotland, I think it would have been harder to come back and convert. But nonetheless, it is possible, just meant more courses. But then in the end, I decided that I did like it here, there, and wanted to practice at the independent bar. And whilst I did find that quite a onerous task in its own right, and it did need several going back to the drawing board and actually getting off that congested motorway and then coming back into it from a side street.
I always like to hear why people go to the UK, and that definitely is quite the explanation. Now, as an international student, or having been an international student, what kind of challenges, if any, I don't want to be presumptuous, did you face when pursuing the law? And that may be whether in the sphere of studying it, if you had any restrictions, or maybe obtaining work experience. Were there any difficulties at all?
The biggest one that stands out to me, and there's a lot more subtle ones, but the most overt and obvious is the fiscal discrimination. And the fiscal discrimination is in the form of you get investors to come in, and by that I mean family, and they're earning in Canadian dollars, and they're funding your tuition and your living expenses in Canadian dollars. And all of that is only about 50%, slightly more, and it changed throughout the years. But generally, I work it as a 50% rule to what the British pound is worth. So no matter what you are earning over here and how hard you're working, when you go to do it in British pounds, you've then got to factor in that what you've done over here, what your investors have done over here, is only worth 50% of that. And then they need another 50% on top to even make that British. So the fiscal discrimination was quite onerous and tedious. And I tried to work it out in terms of an investment to see where I could be in terms of giving them a substantial return on their money. But of course, being family, they're not interested in that. But the point is that it was quite an onerous investment that when you double to convert that back to Canadian dollars, would take a good chunk of time before you can break even to recover, let alone starting to give dividends or any shareholders proceeds on any shares.
Try tripling it, Matthew.
Oh!
Try tripling it, because although we did have the situation with Brexit, and I know this is a bit of a cheeky thing for me to say, but we were low-key hoping, okay, maybe the British pound will be devalued a bit. It will come down a bit. The conversion.
Yes.
Truth and in fact, it's a strong dollar or strong pound, as I should say, and it's really back up there again. And the majority of the time, I'm using a rough estimate. It's usually $3 and something cents to one British pound. So $3 Bajan to make £1. So it's really quite onerous, as you do. And it is something to bear in mind, especially if you're not on scholarship or you're not relying on any bursaries or scholarships from your universities or government. Because, as you say, people are working hard back at home. And when you do see the money, you can't be ungrateful, but it just doesn't stretch,
It doesn't, yes.
It just doesn't stretch. And I know my mom would say, even in a foreign land, it's dollar for dollar. So, they see their pound as just £1, like $1. But we see it, wow, do you see this £1? That's $3.
Yes, absolutely.
The
good news is if you secure the employment there, then you're making the pounds and you bring it back and spend it here. So if you can earn in pounds and spend in dollars, then you're fine. Absolutely.
Yes, better, and it's also helpful for bringing gifts, or bringing stuff, or contributing financially to loved ones at home. it's
Yes.
always it's always better, because somehow your spending power is just lovely coming back home, coming back home. Now,
Absolutely.
yeah, now that we've spoken about that, we did speak about the practicalities of the law. So I'm interested to hear from you. What kind of legal experience do you think law students and graduates can undertake to bridge that gap between academia and the practicalities of the law? Now, I know you spoke about attending court, and that's one big one. Are there any others that you think people can seize that opportunity?
Yes, absolutely. And I've created a very non-exhaustive list on that front. But I've got go to court on that. I've actually put that as number 2, but I think I would reevaluate that and put that as number 1. I'm very much into being that full-haired person. I am reevaluating that phrase because I do think it's moved on. It's no longer a bald-headed man. It is the full-haired person now. And of course, I think Clapham City is London getting bigger. We might have to rework if it's where the Clapham City Omnibus anymore as well. But I'll leave that to other people. But go to court is certainly high on my list for that. And mooting and mock trials. Take advantage of every mooting and mock trial that you can afford with your time, bearing in mind these are extracurricular and they're only meant to be extra. So your focus needs to be on your core studies and your core development there, and obviously achieving those marks. But in addition to that, the core studies aren't going to stand you out on their own. You will need to get more practical footings, and I found mooting and mock trials quite a good way to go achieving that. The next one is the volunteer and the pro bono. I did the National Center for Domestic Violence on the bar course. Then I did some community mediation with Brighton and Hove independent mediators, and then citizens advice. That was brilliant as well. And that was a way to take that academic perspective, put it into reality or practicality, and then also start working with clients, but in a controlled way, so that you're not just let loose, charging them anything, and then there's no quality assurance or experience there to make sure that they've been protected in the provision of the offering legal services. And then there's also mini-pupillages, which I took advantage of as when I could. And then I'm going to add in now, for the purposes of CILEX, mini fellowships. There's also the ability to start those and ask a chartered legal executive whether you can tag along there, of course, with confidentiality agreements, and also making sure that data protection is kept imperatively high, but working on the same principles as mini-pupillages. In principle, there should be no reason why gaining shadowing opportunities with barristers should differ for that of gaining back schemes from solicitors or gaining many fellowships from chartered legal executives. So those are there as well. And then finally, because it's non-exhaustive, sharing. Whatever you do, don't think you need to conceal it to yourself. There will be other people out there that can benefit from that, and you can benefit from them. So if you have come up with a particularly good idea to this particularly good strategy that works for you, that is designed to take you from academia to the practical world sooner and quicker, and hopefully develop a little bit of that USP, share that. And then hopefully somebody in kind will do the same for you by giving you access to a method that they've used that hasn't been out there. So it is about being transmissible. I know it is tempting to view them as competition. And yes, you are competing against them for spots. I completely understand that. And you don't really want to be sharing too much because you might be going up for an interview for a very limited spot. But it also makes it more rewarding that if you secure that spot and you secure it over open-eyed and fair competition, then you've actually been the best. And you've won that all hands on deck, all above board, nothing, you're not taking advantage of anything being concealed or hidden, and just squeaked your way in there. So I do think the sharing approach is quite vital. And I do think that if you've got your list, make that known, and then if other people hopefully will pay that forward in kind.
Agreed. 1000% agreed. Because some persons seem to think, concealing information and knowledge gives you that edge. But on the contrary, as you rightfully stated, you share that information, you give, you receive, everyone benefits. It's fine. We all apply, and may the best person, get the job. At the end of the day, that's simply what it is. There's no point being a hoarder.
No.
There's no point, because when you don't share information, you don't engage in conversation, the other person isn't going to engage you and maybe fill in the gaps where you don't know. So really and truly, you're just doing yourself a disservice. And I think on this point as well, we're both advocates at LPC Law, and I think this is somewhat of a brilliant employment opportunity for persons who are interested in going ahead and being attorneys or lawyers. I'm using that term quite loosely, but who are interested in representing other persons' positions. And I've always wondered to myself, how did being an advocate at LPC Law assist you in bridging that gap?
Oh, it's not past tense. I've really got to put that on the present tense, and it is ongoing and continues to be. And the way that if I could put it this way, because I do love my analogies, as a visual learner, I do try to put things into a kind of more like that practical perspective, if I could relate it back. And one of the analogies that I use, because the practice that I'm tending to develop these days, it tends to be very heavy in road traffic collisions. So I'm getting a lot of motorway examples. And the way that I can picture it before LPC, although I did need to get some volunteer experience and get in the community. So I certainly wasn't on a congested motorway from that side of it. But I was, in terms of the professional exposure, and in terms of developing a professional practice, I was stuck on a congested motorway behind several cars and just breathing in carbon emissions, not going anywhere. So I did need to get off of that congested motorway onto a side street. And then if things go in the future, maybe get back on, but maybe not, depending on where the side streets go. But the point is that LPC allowed me to get off that congested motorway, and it helps me to continue to be able to take a detour and surpass a congested motorway in developing my practice. And it has been absolutely crucial and essential in doing so, and it continues to.
Excellent. And I always say, I know we're advocates, but I always advocate for other persons. If you do have that opportunity, if you do wish to apply, and you're interested in representing other persons' interests, I really think if you can spare the time, you can do it. Apply to be a county court advocate. Apply to be an advocate. It is fantastic experience, and it gives you a lot to talk about in applications, a lot to talk about in interviews, and it's great on your CV. You've actually started to do the things that at one point you were wishing to do. So I really think it's a brilliant opportunity. Now,